Thank you for taking the time. We will get right to it. We have this felony child abuse case that was null prossed by your former attorney. What happened?
Well, I'm really glad that you asked that, Lindsay. What happened is that attorney was leaving the office, and this is an incredibly complicated case. So what we need to do is we needed to give our new attorney, who's going to be on the case, time to get up to speed on a case that is laden with experts, 600 plus pages of a medical record. So what we did is we went in front of a judge, made an argument that prosecutors are not fungible. This case is so complex, we need a new attorney in the office to take over the case, get familiar with it, so that we can bring it back and try it then. And you know, the judge saw that for what it was and agreed, saw that how complex this case was, and agreed with our argument that an attorney handling this needed ample time to prepare.
What's the timeline now?
Well, we're going to be bringing this case back very, very shortly. And I'll say that I'm really glad that we were able to do this because, look, at the end of the day, we're talking about a 2-year-old who suffered a terrible crime. And what we always try to do is we want to put our best foot forward, put on the best trial that we can to increase the possibility of gaining accountability. And doing this, allowing going in front of the judge and allowing ourselves to get a little bit more time for a new attorney to prepare for the case is really going to allow us to do best by the victim.
Nathan gave notice about a month before the case was set to go to trial. Was there really no one that could step in to do a 4-day jury trial?
Well, Lindsay, it's not about having a body. It really is about the complexity of this case. Again, a shaken baby case with a small child with the type of injuries that we saw really requires a lot of work with experts, really requires understanding that voluminous case file. And you know, this is not just me saying how complicated it was. As a matter of fact, the judge in the transcript that we gave you agreed with our assessment that this case is incredibly complicated and would take a lot of time for somebody to get up and running for us to be able to do the type of case that justice really demands.
I know you and your chief deputy were sitting in on the Timberlake case as this other case was set to start. Why couldn't one of you have taken this up, especially with it being so complicated?
Well, it's the same reason why you don't see the police chief and his top commanders walking a beat. When you are in charge of a large agency like we are, our role is to lead the agency, make sure everything is going well, set up procedures, really bring this agency into the 21st century. That's our charge as the 2 top leaders, and I can say that we've really been doing that. I'm excited by a lot of the stuff that we've been able to do. Because that's what we spend our time doing, we've been able to double the size of our office. We've been able to build specialty units for domestic violence cases and crimes against children. We've been able to build new diversion programs and create data programs and really improve our processes to better serve victims in our community. So that's really what my job and my chief deputy's job is.
Was there a confession in this case?
Well, I don't want to get into the specifics of the case because it has yet to be tried, but in any case, even hypothetically, if there is a confession, that does not obviate the need for a prosecutor to get in and really learn the case. Because I've seen cases many times that have a confession that fall apart in front of the jury. If you go to a jury with just a confession, you're not putting your best foot forward. And what we want to do is we always want to put our best foot forward because we have our victims front and center in our mind. And going forward with a case without giving somebody the opportunity to read that 600-page medical file to really talk and prep our experts really would have done a disservice to the community.
The defendant in the case lost the injured child. In the meantime, she's had another baby. She has lost custody of that child too. So I think, of course, these children, their safety is the priority if what is being alleged is true. But people are also innocent until proven guilty, and this woman has been waiting 2 years to go to trial. If she is innocent, she is losing this time with her child. Is her right to a speedy trial being violated?
No, it absolutely isn't. As a matter of fact, again, this was not a unilateral act on our part. We had to go in front of a judge to make this argument because only a judge can grant a null pros. And we made our arguments. The defense attorney made that exact argument, and the judge still found that justice demanded that we have time to properly prepare this case.
Are there other cases where this same thing is happening?
You know, while using, relying on a null pros to get more time for a complex case is something that happens, quite frankly, in courthouses around this state and around this country every single day. We only use it whenever we are really put in a jam where not doing so will really not allow us to do the best that we can for our victims. And really, that's what this is all about, Lindsay. It's doing the best that we can for our victims, making sure that we do everything that we can to get the right results in these cases and put our best foot forward.
I guess the question is just, what about the defendant in this case? This woman that's being forced to wait and wait. And you know, she is maybe indicted again. Wouldn't she be rearrested?
Well, she would be, I would say a re-indictment would restart this process. But again, with the backlog that we have from COVID, we actually have an extraordinary number of cases that are currently set for trial because this courthouse hasn't really done trials for months and months and months. So again, this is not something that we've done unilaterally. This is something that we've done with the permission of the court, whose job, the judge's job, is to balance all of these things and come out with the right result, the right result for justice and fairness. And this is where where he landed as well.
And again, any cases that come to mind where this kind of same thing is at play, a COVID delay, and now staffing delays are pushing things off and even causing cases to be null prossed. Any others?
Not anything that comes to mind.
The prosecutor in this case, Nathan, left. 2 others left last month as well. 3 attorneys. That seems like a lot. Is there something going on?
No, absolutely not. As a matter of fact, you know, 3 attorneys leaving of an agency that's 83 individuals, quite frankly, is no cause for alarm. What you have to understand is that the average lifespan of assistant prosecutor all across this country is roughly 1 to 2 years. And that's because the job is very difficult, caseloads are high, and quite frankly, we deal with individuals reliving the worst days of their life day in and day out. So the turnover rate for a prosecutor's office, or the life cycle of a prosecutor tends to be 1 to 2 years. And that's what we're seeing here. As a matter of fact, I can tell you that, you know, since I took office, we have doubled the size of this office. Right now, we're basically at full capacity. So any idea or any narrative that we're having trouble with resources or staffing is simply not really backed up by the facts.
I had asked for the number of people who have left since you took office here. Do you have that?
It's roughly about 2 dozen. And about half of those individuals were people that we inherited from the old administration, but that's to be expected. You know, Lindsay, I came in wanting to build reform, wanting to change this office and change what the focus is, and we've successfully done that. But that type of change isn't for everybody, and that's perfectly all right. What we have right now is we have an office that's double the size that it's ever been, with prosecutors and staff who are dedicated to this mission, who are dedicated to the idea of criminal justice reform. And we've been very, very successful. I mean, right now we have a jail population that is as low as it's ever been, and crime last year was down almost 10%. So this agency is doing its job, and the people here are bought into this mission and really working hard for this community.
The number I have of prosecutors leaving is 29, and I will check that with you. I have the list. But my understanding is a lot of them were people that you hired yourself who have then left, and so it wouldn't be an ideological issue. Why so many leaving who you brought on?
Well, I'd say that, again, the average life cycle of an assistant prosecutor is fairly short, 1 to 2 years. I've been in office for a little over 2 years. We're going to see some of that turnover. The other thing I want to mention is, you know, quite frankly, compared to what's going on in county governments all across Northern Virginia, including Fairfax County, we're actually doing very well. Just last week, as a matter of fact, the County Board of Supervisors, their personnel team had a public meeting talking about how over the last year resignations in the county have spiked by 62% because of COVID, the Great Resignation, all of these things. So for us to be able to be basically fully staffed with an agency that's double the size of that it was when I came on board really speaks to what we're building here, and I'm really excited about it. And again, being able to do that with that backdrop of what else is going on in the county really shows that we're not having any issues with building our agency the right way.
Have you heard from prosecutors you have hired who are coming to you saying that they feel untrained and unsupported?
Oh, no, absolutely not. I would say that we put a lot of effort into training our prosecutors. You know, one of the things that I want to do in this office is build a 21st century office, drag this agency into the 21st century. And I think we've really done that. Not only have we implemented new training protocols, but you want to talk about support. When I came into this office, we had one paralegal for the entire office. Now what we have is we have a staff that makes sense. Our processes are better. We're no longer having the issue where victims and witnesses are just giving up. We're moving our cases. We're getting things done. So the idea that somebody would feel untrained or unsupported is not anything that, quite frankly, I've heard from anybody in this office.
That prosecutor on the Shaken Baby case, Nathan Fryer, sent an email talking about how he felt untrained and unsupported, saying that he was incredibly overwhelmed, completely unprepared to handle 48 of the worst crimes in our society. He said that he's begun making numerous mistakes and missteps due to lack of experience, handling the complexities of these cases, being completely overwhelmed by pressures and responsibilities, talking about wandering around blind, cases blowing up. I have reached the end of my mental rope handling this many serious sex cases with limited training and no idea how to handle them. What happened?
Well, look, I can't speak to what is in his brain, but what I can tell you is that he came in as an experienced prosecutor from another agency, and you know that may be his mindset at this point. But I can tell you that the prosecutors that we have in the office, quite frankly, don't feel that way. So without having spoken to him about that or seeing that email that you're referencing, I really can't comment on it.
You never saw this email from Nathan?
What I meant is I don't have it in front of me right now.
When you did see the email from Nathan, what did you do?
Well, I'm sorry, I don't understand the question.
Seeing something like this is so alarming. This is a guy that's handling sex crimes cases. This is not someone I would want to handle a case involving me or my family, and I feel like most people in the community would feel that way. This is someone crying out for help. Why was he still handling sex crimes cases after explaining to you how he was feeling?
Well, as a matter of fact, we removed him from those dockets. He started to do other cases because what we always want to do is we really make an effort to put our prosecutors in cases where they feel comfortable and give them the support that they need.
Did you try to help him?
Well, absolutely.
So he did still do some sex crimes cases following this email that was sent in October. Some of them he lost. And then it raises the question, was this person innocent or was the prosecutor inept? What would you say to that?
Well, I would say that anytime you go to trial, there's a risk. And you know, there are any number of reasons why a jury could decide to come with a finding of not guilty. That happens in courthouses across America every single day. As far as any of these issues being raised, you know, anytime, or what we would do in this case would, of course, give him more support and try to move him to cases that he felt more comfortable with, which is exactly what we did.
Did you get other complaints about him from anyone else in law enforcement or anyone else in this office?
I prefer not to discuss. I think that's a little bit down a rabbit hole that's more personnel based than I'd prepare to talk about on TV.
I know you said the Shaken Baby case was very, very complex. Why was this prosecutor the one on it?
Well, with the look, this individual was an experienced prosecutor who, when he was assigned to the case, indicated that this was a case that he felt comfortable doing. At the time when it was assigned, we felt comfortable with him handling it.
I've heard that he is not an exception in this office, that there are other people who feel this way. So I'll ask again, have there been others you have heard from, directly or indirectly, who are feeling unsupported and like they don't have enough training?
Well, all I can tell you is what we've done in terms of offering training and support to people. And what I can say is that we've implemented more training than ever existed in this office. We've implemented more support than has ever existed in this office. So we are putting our money where our mouth is and really building these systems to train and support these individuals.
Do you have an open door policy where people can come to you?
We have, I talked to the staff fairly regularly, but like in any large organization, we have we've built a hierarchical leadership team, and all of that information flows up, as it should in a large organization like this, through that hierarchical structure.
I understand, you're about reform and doing things differently. I think you see that, though, and you ask, how can you really reform a system if people don't have the basics? They aren't grasping the 101s of prosecuting. And so again, seeing something like that raises the concern that people are flying blind, or, as Nathan said, feeling untrained and unprepared to do the job here.
Well, I would push back on the idea that people are flying blind and they can't get 101s.
I was just quoting from, what he had relayed.
Well, as a matter of fact, not only do we have a number of experienced prosecutors in the office, but we've recruited experienced prosecutors not only from around the Commonwealth, but from all around this country. So we are really building, quite frankly, an office that matches experience with also the commitment to the values of reform.
Last question on Nathan. On the cases that he did not win, specifically the sex crimes cases that he was on after that email, do you feel confident that those cases were prosecuted the way they should be?
Absolutely. Look, you have to understand that I think some people have a misunderstanding that prosecutors come in and they win every single case that gets put up in front of a jury. That's simply not the case. There are any number of reasons why, when a case goes to jury, the jury doesn't see it the way that the prosecution wants them to see it. Again, this is something that happens in every single courthouse, in every single state in America, every single day. It is, not pleasant when that happens, but that is our system, and we have to respect the jury when they reach a verdict for whatever reason they reach it for.
Do you understand why victims in the cases he handled may question now whether they got justice?
Well, anytime a victim feels that they didn't get justice, it hurts me personally. I come to work every day, and my prosecutors come to work every day with the victims front and center in our mind. We're the ones who go home every night hearing their stories in our ears. So the idea that there are victims out there that feel that they have, that feel like that may feel that way, is personally painful to me. But that means that every day we come and we redouble our efforts to do the best that we can with these cases for the people who've been victimized in our community.
Other concerns that some people have are that victims are not getting justice more generally, that felonies are constantly being pled down to misdemeanors. What do you say to people who've worked in this office or members of law enforcement who feel that victims are not the focus?
I hear that complaint a lot, and I always hear it from people who have a political axe to grind. As a matter of fact, we're talking about that complaint that comes from, a Republican Attorney General, and people who really will do anything, including weaponize the trauma of victims to try to kneecap reform or to gain political points. I've seen it for 2.5 years I've been in this office, and I've seen that effort redoubled over the last couple of months. The fact of the matter is that we are always focused on the victims, and if these individuals who want to score political points, if they feel no shame about trying to weaponize the trauma of victims, then that's their issue, and I just hope they can sleep at night. I know that I can sleep at night because me and my team, we always put the victim first, and we always do what's right.
I can tell you honestly, the people that have heard this from are members of law enforcement within this community, some who have been doing their jobs for many years and have been through different administrations, but still are saying, I don't feel like I can look victims in the face when I see what kind of things that are happening with the plea deals that are given to suspects.
Again, this is, quite frankly, even from those quarters, these are politically based arguments.
But some of the people are people you've actually hired yourself who wanted to work for a progressive prosecutor.
Well, look, you're asking about two different sets of people at this point. So let me, if you'd be so kind, let me
I think,
address
again,
the first set,
it's generally law enforcement in the community. We're not talking about Jason Miyares. We're not talking about the people trying to recall you, but truly people who work in law enforcement. And again, some of them have worked in this community for many, many years. And I'm specifically talking about their concerns.
Well, their concerns are, let me say to those people, again, when you try to change something, and we're changing things, we're dragging this criminal justice system into the 21st century. Some people don't like change. The people who have been here and been doing the same thing that works for them, but may not be working for people in the community. I've seen some of these individuals that they will say or do anything to try to kneecap that change. It's very unfortunate. All I know is, again, what we do every day is we put the victims front and center. We are working hard to build a safe community, build long-lasting safety in this community. And I think right now you're seeing that, again, crime in this county is down almost 10% year over last, meaning last year we had less than 3,100, we had more than 3,100 fewer victims than we had the year before. So the idea that somehow this is making our community more dangerous or we're anti-victim simply doesn't hold water when you look at the facts.
I think specifically people are talking about violent felonies being reduced down to misdemeanor offenses. Is that something that you push here?
No, as a matter of fact, I have to say the complaint about violent felonies being dropped down to misdemeanors, again, that is a political talking point from people who have a political axe to grind, who really want to kneecap reform. We take crimes of violence very seriously. When you're talking about reform, what you're doing is you're looking at crimes of violence one way, and you're looking at everything else a different way. You know, the idea that we're knocking down violent felonies to misdemeanors for fun simply doesn't make any sense. What we do in every case is we look at the facts, we look at the evidence, and we do the best that we can with that case. For example, I have gotten a lot of heat from our Attorney General about doing just that. But when you actually look at the facts of the case, the evidence presented, all we're doing is our job.
One case that's gotten a lot of attention lately is the Gerald Brevard case, where he was charged with some felonies. They were knocked down to misdemeanors. He was able to go on to do some allegedly really awful things. Do you have regrets about how that case was handled?
Well, that case was handled according to the evidence that we had. Quite frankly, with the evidence that we had, those felony charges, we could not make those charges. We were missing elements of the felonies. All we were able to prove were the misdemeanors. So instead of doing what our Republican Attorney General and his ilk and the people who hate reform would want us to do, which is just blow past our ethical obligations as prosecutors, we did the right thing. We were able to get a 2-year sentence out of that case, mandatory mental health evaluations, and you know that is why we did what we did in that case, because that is what we could do with the evidence that was presented.
He had that magazine that would have been a felony that was discovered. I know people have said that's something that he could have served some serious time for if you went ahead with it.
Well, first of all, when you say went ahead with it, that charge was never brought by the police. And that charge was a charge related to that magazine was never brought by the police because that magazine was discovered much later, after he had after it could no longer be tied to Mr. Brevard. So again, the idea that that is a charge that we should have done something with. Again, it is a bunch of people who are acting in political bad faith, who are taking advantage of the general public's unfamiliarity with how the system works to try to score political points. And when you take a look at that case, and you see the pain on the other end of that case, when you see, as you mentioned, the allegations against this individual after his release, I think it's really bad taste. As a matter of fact, I think it's disgusting that these people would try to use that tragedy for political purposes.
I don't think about anybody that's doing that. I think about the people that lost their lives and the people that got hurt. Like, those are the people that matter. And if that was my loved one, and I realized this guy that allegedly was the gunman could have been locked up, he has this long, dangerous past, and here he is in Fairfax County committing these really awful crimes, trying to hurt people, and this is not someone that should be on the street. This wouldn't be somebody that should be given another chance. This wasn't somebody who had a clean record and maybe messed up, and he wasn't supposed to have weapons. And so I think, putting aside any kind of the political stuff, it's the people that got hurt, that I hurt for, because you realize in a different scenario, this man could have been locked up.
Well, Lindsay, I have to say, the facts of the case don't back up what you just said. He did have, the facts of the case just simply don't back up.
He did have a long past, a long criminal past,
but
right?
That is unrelated to what the evidence presented for these particular facts are. The idea that that a prosecutor would blow past the evidence presented, ignore the holes in a case, and just say, oh, this guy's got a bad record, and try to prosecute off of that, would be unsuccessful. Because when you don't have the evidence, it doesn't matter.
I mean, sometimes you lose, obviously. I mean, I know with the Timberlake case, you said the standard isn't whether it's easy or hard. You got to put it out there to the jury.
Well, let me say this. When a case is hard and you have the evidence, you go in front of a jury. When you don't have the evidence, which we did not have in the Brevard case, you do the best that you can with the evidence that you have. And the evidence that we had, what we were able to do with that, again, you get a 2-year sentence, 11 months of that was supposed to be active time, and a mandatory mental health evaluation. That is what we were able to do with the evidence. And quite frankly, anybody saying that that is not what a prosecutor is supposed to do is quite frankly trying to sell you something.
How would you describe your relationship with law enforcement in the community, the Fairfax Police Department, the Sheriff's Office, and the smaller police departments?
Well, I think it's, quite frankly, I have a good relationship with large swaths of our police departments, and I think it gets better by the day. As a matter of fact, I'm the first Commonwealth attorney. Me and my team were the first ones to go to every single homicide scene while the detectives are still working, because we're working that closely with our law enforcement partners. We're doing a lot of things when we're talking about bringing this office into the 21st century. What that means is, in many ways, a greater integration with police detectives and law enforcement, so that we can get better outcomes in our cases and start that work even during times of investigation. So I wouldn't say that it's a relationship that doesn't have its bumps. Of course, as the Commonwealth's attorney, it's my job to keep somewhat of an arm's length relationship with our working partners, because we are the office that, if something goes awry, we have to be able to hold individuals accountable, and the public needs to feel comfortable that we'll do that if the situation arises. But I'd say overall the relationship is good, and it gets better every single day.
I wanted to talk about what happened at the security checkpoint here at the courthouse in September, resulted in some sheriff's officers being put on the Brady list. Why did you put them on the Brady list?
Well, first of all, let me say about that incident, it is something that got blown way out of proportion. And it never should have reached the heights that it reached in terms of getting blown out of proportion. But it's the situation that it was. And what we saw when we reviewed the written report and what we saw when we watched the video simply didn't match. And it's our obligation as prosecutors, when we have a law enforcement officer who has a demonstrated history of not being able to accurately portray what was witnessed, that we turn that over to defense attorneys in any case that they're a witness on. And that's not ascribing motive or anything of that sort. That is legitimately us just doing our job as prosecutors, fulfilling our constitutional obligations.
Did you curse at those security officers that day?
All I can say is, or all I'm going to say is that what was represented in that report was not completely accurate.
I think the hard thing is, you're right, the video has no sound, but you were there, there were other people there. So what I want to know is, without the video, what actually happened? They said that you cursed at them, that Kyle Manicus cursed at them, and you said, "Don't you know who I am?" Is that accurate? Is it the truth or a lie?
That's inaccurate.
All of it is a lie.
What I said was, all I did is went through the checkpoint, and I asked the gentleman, would law enforcement have to go through the checkpoint? And then we got into a conversation of, no, they don't. And I was trying to explain, oh, well, I'm law enforcement too. Then eventually they got to the point of essentially, well, you have to talk to your boss. And I was just trying to explain to them, oh, you don't realize all the prosecutors here, they work for me. I'm the boss of this office. And we were talking through masks, and it was loud. It made it difficult to hear. But that really was the gist of the conversation, just me trying to ask them and get clarification about what the rules were for law enforcement who came through that checkpoint.
Was there cursing?
I did not curse at these gentlemen.
Kyle?
I'm not going to sit here and talk about what my chief deputy did or didn't say. Because again, I was engaged in my own conversation with these individuals at the time.
So they lied in that report by saying that you cursed at them?
See, I think that ascribes a motive to why.
The report was inaccurate when it said you cursed at them. Is that right?
The report had a number of inaccuracies, and as a matter of fact,
I just want to nail down exactly what was wrong. Because, again, we don't have video, we don't have audio, so what actually happened? Well, some video. As you noted, I know, it doesn't show the entire encounter, it's just from the one perspective.
Well, the video actually does show the entire encounter, and the reason that we know that it's inaccurate is we weren't going off of my memory. We weren't going off of anybody else's memory that was there. We saw the video, and we saw two very distinct things that were in the report that the report said was backed up by the video, and they simply weren't. The first one was that two Fairfax County police officers came through the security checkpoint. No Fairfax County police officers came through the checkpoint. The report specifically said that the video would show that they did not. The second thing is that the report indicated that the security officer turned his screen to show myself and Mr. Manicus something on the screen. That clearly never happened. And what's really important about those two things is those are purportedly from the report, the two precipitating events that started this whole kerfuffle. So when you take a look at the video and you take a look at the report, they simply don't match. And quite frankly, that's just not me saying it. There were numerous news reports who went and saw both things.
I think there was just one.
Very clear.
But you can't see what happens before you're going through the checkpoint. Believe me, I studied this video very closely. So did he. You can't see any conversation or interactions before you put your items in and come through. And presumably that's where the conversation happened, where you were told you had to go through. And it brings me to another question, which is on those days where everybody has to go through, which is mandated, I believe, by the chief judge. When that happens, do you go through and get checked?
Oh, I actually, the judges, the sheriff, and I, we actually we typically park in a different lot. We do not have to go through that checkpoint. I just happened to go through that day because I happened to see people on the street and decided to walk in that way.
If you were to go through there, you would have to go through though, because every single person has to. Was how it was explained to me on these particular days.
As it was explained to me by the individuals there, law enforcement doesn't have to go through, and that was the gist of our conversation. But rest assured, I don't go through that entrance anymore, so it's not an issue.
The sheriff's office cleared those officers and said they did nothing wrong. Why not take them off the Brady list?
Because the Brady list is completely different from internal affairs. The Brady list is a constitutional requirement that prosecutors have as part of their ethical obligations that are completely separate from what an agency who does an internal affairs investigation, who is looking at something completely different, would come up with. So really those two are completely unrelated. And again, when you take a look at the video and you take a look at the report, what you see is they don't match. And therefore, we really have no choice as prosecutors, if we're going to fulfill our obligations ethically and constitutionally, than to flag those individuals should they ever become a necessary witness in a case.
Did you participate in the sheriff's investigation?
Well, as a matter of fact, well, I'm sorry,
The sheriff asked you to participate in the investigation. What did you say?
Well, as a matter of fact, we didn't ask for an internal affairs investigation at all, and as far as
It was their investigation. They wanted you to participate in their investigation since you were a key player.
Well, as I understood it, the investigation, which I was able to review, was all about the writing of the report. And the writing of the report is something that I had nothing to do with. As a matter of fact, I didn't even know that there was a report that was written until we were made aware of it. I believe somebody in the news called us about it. So clearly we didn't have information that was relevant to the writing of the report, so there was no need for us to involve ourselves in the investigation.
Sheriff Kincaid wanted you to talk for this investigation. Why not do it?
Because we would not have had we wouldn't have had anything to add to what they were investigating, because again, it was about the writing of the report.
From your job, you know how important it is to get every witness, to get every person involved, to really do a full investigation and find out exactly what happened. Why wouldn't you participate?
Well, it is important to get, it's important to get the witnesses that have something to say relevant to the investigation. This, again, the investigation was about the writing of the report, which I had no knowledge of.
So this is where it stands. They are going to stay on the Brady list, and that's it.
Where it stands is I did my ethical obligation, my ethical duty as a prosecutor, and I fulfilled my constitutional obligation, and will continue to fulfill my constitutional obligation should these individuals ever become witnesses in this case. Has
the sheriff come to you and asked you to take them off the Brady list?
Well, I'd prefer not to get into conversations that I had with Sheriff Kincaid.
There was an attorney in the office who ended up being unlicensed for a time. What does that mean for her cases?
Well, that is, and what you're referring to is an attorney who, for a very short period of time, accidentally had not paid her bar dues. I think it's important to note that it's not because of any bad acts on her part. It's administrative because a check didn't get put into the mail.
Mm-hmm. Was that your fault, your office's fault, or was that her fault?
I'm not going to sit here and cast blame on my prosecutor.
Typically, I've heard that this is something that's handled administratively by the office.
Right, that's what I'm saying. I'm not going to sit here and blame my prosecutor. What I'm going to say is that our office, we should have done a better job of making sure this got done. I take full responsibility for that, and now we have processes in place that redouble our efforts to make sure that that doesn't happen again. As far as what happens with those cases, we did what we're ethically obligated to do, which is we reached out to every single defense attorney, we reached out to the bar, and we're going through any court process right now to determine what effect that they would have on prosecutions. It's our position that because this was administrative and merely monetary based failure, not anything to do with this individual's performance, that it shouldn't have any effect on the outcomes of these cases. But again, that's something that could change should a judge rule differently.
Has anyone petitioned to have their case retried at this point?
Not at this point, no.
Do you know how many cases?
Oh, I don't have it offhand.
This was over a period of 4 months?
Roughly.
Maybe 24 cases or closer to 12?
I really couldn't tell you.
A lot of sex crimes cases?
Potentially, but again, without having the list in front of me, I couldn't. I don't want to give you inaccurate information.
Are you concerned about what's going to happen as a result?
Look, I'm always concerned when something doesn't go according to the normal course. But again, I feel that because this was merely an administrative oversight, that there is case law that is pretty strong in our favor that would allow those cases to stand.
Anything else that you would like to say or think people should know?
Well, I would think that the one thing I want people to know is I'm really excited about what we're building here. We are dragging this office from the Stone Age to the 21st century. We are reforming our criminal justice system, and we are keeping our community safe. We are building diversion programs. We're helping people, and at the same time, we are helping to drive crime down and keep this community safe. So I'm really excited about what we've been able to accomplish in 2 years and 4 months, and what we're going to accomplish through the rest of this first term.
Thank you.
Yeah, thank you, Lindsay.